Okay, welcome everyone to this first workshop entitled Introduction to Mooting. So presented by myself. I'm Jaidyn. Nice to meet you all. It's good to see all of you coming out tonight. I really appreciate your support. So this session will be teaching a lot about the basics of mooting. You'll learn a lot of small ideas that will work well towards the bigger picture towards the end when you come to actually present your moots. If you have any questions regarding this presentation or anything about the moot in general, just feel free to send me an email or give me a call. I'm always usually available. I do work full time, so please do note that. But outside of 9 to 5, I'm usually pretty available. So yeah, let's just get started. So tonight, I'll just a little bit of an overview, if my PowerPoint would work. We'll just go over the standard structure of a moot, how we do the research and development, which luckily you guys won't have to do too much of because I've given you the cases which you need to rely upon for the moots. How to write written submissions, which is kind of important for the moot, as you will have to do that. But please do mind, in the junior moot, it's only worth 5 marks at a total 100 marks per round. So it's not essentially the most important thing. Yes, they can be very timely, and as I'll explain later on, but it's not, if you don't do particularly well on them, it's not, end of the world. As long as you can speak in front of people, you'll do okay. Because the oral part in this moot holds 95% of your marks. So, as long as you can speak in front of people, it's fine. Okay, also we're going to talk about questions from the bench and how to answer them, because that's the trickiest part of mooting, is getting questions from judges. Then we'll do a quick presentation, talk about the moot itself, talk about any opportunities, and I might do a little bit of a practical exercise, but we won't have this included in the recording, but I will put up what you'll have to do. It's called an entrance of appearance, which is pretty much the first thing you say when you walk into a courtroom, or when the first thing that the judge will do. They'll come in and go, take appearances, but we'll get to it when we get to the end. Okay, so what is a moot? So you guys would have heard a little bit about this as you've signed up for this comp, but in simple terms, it's a simulated court case that usually takes place in an appeal court. You can get like an original jurisdiction case as such, but it's really rare, especially in Australia, where we look at appeal stuff much more. Okay, so what can it involve? It can involve almost any types of law. So for example, this year's championship moot question was one of criminal and evidence law. So evidence is quite a tricky type of law. You'll study it in 30 years. I don't think anyone here would have even gotten close to doing it because you got to do 16 subjects, but you'll find out evidence is quite tricky and applies to almost every type of law. But it can be civil, it can be admin, it can be property-based, it could be anything. And most questions usually involve a bit of a mixture of facts and law. So you'll have your facts that are in the actual scenario given to you and a bit of law about, what applies as such. So for example, if you're looking at a criminal case in Queensland, which is based in Queensland like ours, for example, you'll be looking at criminal statute as such and some criminal cases to support your arguments. And they're used generally in a mixture to try and create an interesting question. I generally find criminal questions to be much more fun when compared to civil or contracts-based questions, because it's not as flashy, whereas criminal, you can have obviously the gruesome murders or just, much more fun cases. This one's a little bit on the drier side because it's a drugs-based case, but it's quite simple, so it's mainly based at, getting used to the skills of mooting. So moot problems questions are generally typically quite balanced. So as I've said before, we're doing an appellant type of moot, where there's an appellant who's trying to overturn the verdict of the original judgment of the lower court, and respondent, which is the one trying to keep what we've already got, what the judges have already decided, and just uphold it at the higher level in the court. So generally are quite balanced from both sides to be facts. And this one, I will say, it's a little bit slanted towards the appellant, but that won't make an impact really, as mooters really aren't scored on who would win the case in real life, but rather on how you present on the day and who presents the better arguments as such. Your argument might fail in court, and it might be succeeded by the other side, but the fact is the way you argue it is the way you get marks. And the strong mooters with strong manner as such usually tend to do better and tend to win, even if their law isn't the best or more supportive. So as I've just mentioned, really, the way to win a moot often isn't based on just your legal arguments alone. It's about your skills, answering questions, following appropriate court protocols, and presenting with good manner. So if you look in the rules score sheets, placed towards the bottom as an Appendix 1, and that's how we score you. So we score you out of 100, and I believe like 30 points is dedicated to manners. That's just your stage presence as such, and how you work with court protocols, like how you address the judge. You don't say, "Oh, just judge, hey." No, you address them as Your Honor. So every time you address the bench, you'll say something along those lines, something formal to note that you're addressing them as such, and not just using casual language. Okay, so the standard structure of a moot is usually 2 teams and bench of judges running from 1 to 7. So you can have up to 7 judges in front of you. That'd be quite terrifying, especially if you're one little advocate, especially in uni in the first year, if you had 7 judges in front of you. That won't happen in this comp. I think the maximum you'll have is 2, and that will be for your second round. I'll talk about judges in a bit later on. But you can have ex parte moots where it's only just one side. That's usually in rounds where a team forfeits as such. However, that won't happen in this competition. If we do have an uneven number of people who are competing, we will do what's called a 3-way moot, where we have 2 people represent one side and 1 person represent the other. So it'll go, how it'll run will be that the appellant will speak first, and that's how it has in every normal moot. That's fine. While that's happening, we'll have a second appellant who'll be sitting outside. They won't be able to hear anything that's happening in the first round, so they don't get an advantage or anything. And what will happen is after the first appellant finishes speaking, the second appellant outside will come in and stand in, and we'll hear the respondent, who's the person trying to uphold the arguments as such. So both appellants will get the chance to hear the respondent speaking. And then after that's done, what will happen would be the second appellant will then get up and speak. So that's typically a bit of a twist because the appellant usually speaks first. But that's how the way we deal with moots. And in those moots, we'll usually allocate, if it's a quarterfinal round, we'll usually indicate 2 winners. But in a general round, it doesn't really matter who wins. We'll give 2 winners. We'll give first, second, third. So first, second will technically both win. They'll both get the same amount of points in most comps. But in our comp today, it'll just be balanced on what your scores really are. So you can come second and be like 1 point. Let's say the winning person gets 85, and the second place team will get 84, and the last place team gets 65. So the winning teams will be the 2 higher ones. So we'll talk about that later on as well. Okay, so the timing varies depending on the competition. So for ours, it'll be 12 minutes. So you'll be speaking for 12 minutes at maximum. So you can speak for a little bit under. I'd probably advise you probably not to go anything under 8 minutes. But we have up to 12 minutes. After that, the judges will stop you. Sometimes they'll let you speak for another minute or so just to finish your point, but other times they'll just cut you off. So just be aware of that. So at the start of the moot, both teams will give what's called an entries of appearance, which I'll talk about later, but essentially that's you just opening, you explaining who you are and who you're representing. So for example, a common entry of appearance is such. May I please the court, my name is Paroz, initial J, and I appear for the appellant, Mr. Smith, in this matter. So it's simply just explaining who your last name is and initial first letter of your first name, and explaining what side you represent and who your client is. Okay, so after this, the appellant speakers then give their submissions, followed by the respondent speaker. And after this, there will be something called rebuttal and rebuttal. You don't have to worry about this in this competition, but pretty much it's essentially they get to rebut points. So the appellant will get to rebut a point that the respondent made. But that won't happen in this competition. It's quite complex and it's very tedious to learn. It takes a really skilled advocate to learn it. Okay, so research tips. So this won't really apply as much. This is more around if you were involved in a comp where you weren't given a lot of cases. So all of the cases I've given you at the moment are the ones you'll need. So you'll learn about the parity principle, and you'll learn about serious drug offender confiscations, or SDOs as the DPP would call them. And you'll learn about them through those 3 cases that I've supplied you with. You can also use the legislation, which again, this should be easy. It's noted in the case itself. So I think the criminal code's in there. I think there's a Drug Confiscation Act as well, and there's a third one as well. If you look at those 3 and those 3 cases, you'll know everything about the moot. You won't need to do any further research, so it won't be too bad. But essentially, if you are researching for a moot and you had, for example, the championship moot doesn't give you any cases at all, you just have to go off from scratch. Just use IRAC. A lot of you would have heard this from legal writing research, pretty much it's this issue. So find the main issue of the question. So that's usually within the grounds of appeal. So we'll quickly just swap over the question. Let's open it up. If you can see that, this is the question. And your ground of appeals are right there. So that sets out what the main issue of the whole moot is, what the issue is, what you're arguing over, really. So if you're the appellant side, you're arguing that insufficient weight was given to the parity principles. That's the sentence imposed by Opperman J left the appellant with a justifiable sense of grievance. If you're the respondent, you're arguing that the insufficient weight was that sufficient weight rather than insufficient weight was given to the parity principle, so that the sentence imposed by Opperman J left the appellant with a justifiable sense of grievance. So they did leave the appellant with a justifiable sense of grievance. And in regards to the second ground of appeal, if you're the appellant, you're arguing that the public interest was not in favour of the serious drug confiscation order being made, and that insufficient weight was accorded to the personal circumstances of the appellant. But if you're the respondent, you're arguing the public interest was in favour of making the order, and that sufficient weight was accorded. So you can see it's a bit of a flip. We'll go back to the PowerPoint now. If Zoom's going to let me. And of course, okay, so written submission. So I probably should have said in the other slide, really, but I'll just explain what written submissions are. So we'll just pop over. So I've given you guys an example of what they are. I believe I've sent you all a copy. If you don't have a copy, please let me know. But essentially, they'll look something like this. So this is a copy of the USQ's Law Society's first year moot from 2021? No, 2020. So pretty much, this is an example. So how you write written submissions is a bit tricky. And you get taught about this when you do third year subjects. But essentially, you're doing what I would call IRAC again. So as you state what the moot is, who the appellant is in a little table, who the respondent is in the table below, and then you outline what side of the argument you're for. So for the moot, you'll need to present arguments for both the appellant and the outline. So they'll both be due in the same night. I'll let you know by a withdrawal what side you're representing first, but on the day you'll be representing both sides. So you need to prepare arguments for both sides. So essentially it's IRAC again. And we do have footnotes. Some comps don't allow footnotes. So you just have to do in-text referencing. For us, we use footnotes. So they're really important. So essentially it's IRAC. So the first heading is always what you're arguing. So if you're in this case at hand, you're arguing that parity principle, insufficient weight was given to the parity principle. So that's what you put up there. If you're the appellant, if you're a respondent, you're doing the reverse. And then you just explain what the appellant's overall submissions is. So in this case, I've used the word applicant. You can use the word appellant, that's fine. So I've said in this case, the applicant submits that the respondent party, Espresso Coffee Machines, strongly repudiated the contract when they made it clear they could not deliver on time. And then, so then you go to the rules, then your application, and then your conclusion. So your submissions as per the rules are allowed to be up to 4 pages. You can go under that, but you can't get over, unfortunately. It's just to be more, make sure you're concise. Written submissions are often, I'm going to say, the trickiest part of the first year moot. It's something that's really hard to pick up on, but that's why it's only worth 5 marks. So really, if you just put something on the page, you're going to get 3 marks because the judges usually are quite nice, especially. So they're not going to give you anything lower than half the marks. So even if you put some random words on a page, as long as it looks decent, you're going to get 3 marks. So that's 3 marks out of 100. It's a small amount, but it can make a difference in a moot. Does anyone have any questions about written submissions? No? Cool. We'll head on. But yeah, it's the hardest question, really. This is going to be the hardest part. And I will guarantee this will be where you struggle. Oh, yes. Before we move on, at the end, you've just got to put what orders you want. So if you're the appellant, you want the appeal to be granted and explain what orders you want. It's not even the question of what orders you do want to seek. And for respondent, you just say the appeal should be dismissed and the conviction upheld. Easy. You can do a lot of research on this. Written submissions isn't going to be something I'm going to do too much in detail in. I think Tracy is going to run a workshop if everyone is happy to come along to that. But if you're not interested, we won't run it. So just let me know sometime soon whether or not you are, because it's not worth running one if there's no one going to show up. Yeah. Okay, we're going to return to I pause my screen sharing. Cool. So you mightn't have seen that. I do apologize. Cool. We'll move on to questioning. So this is probably the hardest part. Screen share again. New share. PowerPoints. Okay, so while you are delivering the lovely speech, again, I've given you an example of the speech. Pretty much it's just elaboration of what you're arguing in your written submissions. And we'll go through a speech at the end, I think, because that's the main thing. While you're arguing a speech, the judges are going to ask you questions. So in the junior moot, they're not going to ask you too many. There'll be a couple. It'll usually be simple to try and, get you to have some thinking and have some thoughts about the question. So for example, they might ask you just the overall submission, why? Or they'll ask you something about why your argument is more persuasive than the other side's. Or just some simple facts like how old was Mr. Randall when the offending occurred? Did he have a wife? What facts support your argument? It'll be simple questions like that. They can come up with some really complex questions. And I can tell you, for example, I've done this myself. So the question you're using today was done and has been used before. So it's not particularly too hard. And I can teach you a lot about it because I was quite experienced with it. So if you have any questions, just let me know again. But pretty much when judges are asking questions, always take some time to consider the judge's questions. If it seems confusing, it doesn't make sense, doesn't seem confusing. It's like some judges will just go on for half an hour. Quite literally, they'll just sit there and talk and talk and talk and talk. So you'll be sitting there trying to figure out, you'll figure an answer to the first part of that question, but then you'll lose it because they'll talk about the second and third part of the question. If they seem confusing or the question's gone too long, it doesn't make sense to you, just simply ask them to repeat it. A lot of the times they'll realize what they've done and they'll just rephrase it in a really simple way. If you're going to need to take a moment to answer their questions, just take it. Don't try and rush a response, especially if it's not going to make sense or it's incorrect. Judges, they appreciate your speed, but if you're going to get them the wrong answer because you're going to be fast, they're not going to like that at all. Also, I'd probably advise when you're answering questions, for example, there's just an etiquette when referring to the bench, as I mentioned a little bit earlier, is always reply or start your reply somewhere similar to with the words Your Honor. So that's just a meaning that you're addressing them properly and proper court etiquette. You notice this in real courts. So answers should be like, Your Honor, I acknowledge that and I agree. Your Honor, that's wrong. Well, no, don't tell them that you're wrong. So it's not the best way. If you want to tell your judge you're wrong, just say, Your Honor, that's not correct. Something simple, but you've just got to be more, you've just got to make sure and be mindful and respectful. So a lot of questions they'll ask you though, the best answer is usually yes, no, or it depends. So sometimes they'll ask you some theoretical law. For example, does the case of Garnet apply in this matter? And the best answers are often yes, no, or it depends. So you can say yes, Your Honor, and then a little bit of an explanation as why. No, and then just explain. Or it depends because, law's fun like that. It can really depend on the circumstances. And finally, if you don't know how to answer a question, please just don't say, I don't know. Instead, follow court protocol and just say, I'm unable to assist the court in this matter. It's a polite way of saying it, and I'm getting your points. And I respect that, and I'll move on. Any questions about questioning at all? Okay, so what to do in the moot? So try not to panic. It's kind of hard to because you'll be really nervous as such, but remember the judges are more likely to be afraid of you than you are of them. So lots of them get quite scared of judging students. They don't want to upset you or throw you off at all. Try not to panic. Take a breather if you need it. As I said before, they'll appreciate it. They'll give it to you for a bit. Hold the lectern if you're doing it in person, or hold something if you're online, just for stability. Try not to say or use filler words, and never underestimate the words of Your Honor. It's a simple etiquette, and it's good if you can follow it. So I'm going to let you know on this competition. So I mentioned that we're going to do practice sessions. So myself and Tracy, our president of Law Society, we're going to be your judges for round one. So we're going to be quite nice to you, and whoever you have as your practice session judge will be your judge for round one, just to ease you in a little bit. We're not going to be very harsh at all because we both did the championship moot this year, and we know how it feels to moot. We know it's a bit scary, so we're not going to be quite mean. We're going to try and make it a comfortable environment for you to present well, and we'll give you a lot of good feedback, which will help fully develop your skills in future. Even if you don't ever do another moot or even appear in court, you'll learn something from it. It's an amazing experience doing this, so I'm happy you all signed up. Okay, so we can do a little bit of practical. I'm just going to pause here. Okay, so it was practical, but for those of you watching on Zoom, I'll just quickly pop it up. It's just an example of an entry of appearance of how to do that. So essentially it's, may it please the court, my name is last name initial letter. So if your last name's Smith, initial T, or if your name's Terry Smith, it's Smith, initial T. And I play with my Leonard Jr., which you won't have to worry about because you don't have a partner for this one. I should have mentioned before, we're just doing this individuals as such. You don't have to worry about the whole team dynamics because that adds a whole complexity to the whole situation. So Brown initial C, acting on behalf of the client as the appellant in this matter. So it's pretty simple. Just some other things I'll quickly run through as well. You have other opportunities to moot, so it's not just the junior moot, you have the championship moot. There's lots of Australia-wide ones, so I like Wilk, which is Queensland-wide. The ALSA competition, which is the national titles, which I recently got to judge at, which was cool. The Jessup competition, which is a prestigious international comp. You'll need to talk to Anton Levin about that. He will tell you millions of things about that, but essentially, if you can win, you go over to the Washington, D.C. If you win the Australian rounds, you get to go to the Washington, D.C. and moot in the Supreme Court over there. So we've also got other ones as well. There's so many in Australia. So it's not the only type of mooting though. There are others. I'm not going to really talk about them, but it's client interview negotiation to witness X. You can look it up on our website. We've run all these comps before, or you can look at ALSA. So any questions before I quickly run through a speech at all?
How do you progress to the finals?
Yes, good question. So how do you get through to the finals? So pretty much, I'm going to bring up, I'll see if I can find the rules. So it's all noted in this lovely, the rules are really good as well. I've sent you all a copy. They can be a little bit long. But hey, that's how it works, I guess. Unfortunately, I had to go through and write these. So yeah, they are a little bit long. But essentially, competition structure. So under number 3. So the junior moots comprise of at least 3 rounds, 2 prelims and a grand final. So 2 sides. Let's see, where do we put it? Procedure. So the draw of competitors will be conducted by myself. I'll send that out to you at a later date. Where I'm not going to send it out to you too early on. I'm going to leave you in suspense. So I know you're going to hate me a little bit for that, but that's okay. But pretty much, as I mentioned in the email, we need 8 people to run a semi-final round, which will be 4. So essentially, the winning competitor of each match will be the competitor with greater number of points. But how we're going to have it to go through will be the 4 competitors. If we're doing a semi-finals, it'll be the 4 competitors with the highest points from preliminary rounds 1 and 2 will progress through in a round robin style. So it'll be 1 versus 4, 2 versus 3, and the knockouts progress to the grand final, pretty much. If we just end up running a grand final, it'll be the highest 2, and they'll be against each other. And how we'll determine who has what side will be through a coin toss. And also sets out what a 3-way moot is as well there. But how we do the scoring, I'll bring that up. So a lot of these rules, I think you should give a read through because it outlines what you need to do. So there's some stuff, preparation and research as such, written submissions. That explains you've got to send that in to me 48 hours before the round. Again, the rounds are going to be held in September, so you've got plenty of time to work on it, and I'll email you before then to see how you're going so far. So oral arguments, as I said, 12 minutes, explains what you need to do. And explain the bell. So at 10 minutes, you'll get a bell explaining that's 10 minutes. So the judges. Okay, so that's your marking criteria right there. So 10 marks for organization and presentation, 25 for development of argument, 20 from questions to the bench, 30 from manner and expression, and 15 marks for written submissions. So that'll be reduced to 5, and I'll designate the other 2 points away. Let's have a look at the bottom. So that also, yeah, we're going to keep this 15 for now. So I do apologize. It'll be worth 15 marks now. That was a change from last time around. Last time was worth 5. I forgot I had bumped that up to 15. So it'll be worth 15 marks instead of 5. So I do apologize for misleading you. But again, if you literally just do a satisfactory job, you get 8 marks. So that's still a pretty decent amount of marks to get. And that's what your score sheet will look like. And yeah, I will also let you know what campus you're competing at. So I know that people have signed up for Toowoomba and Ipswich in Zoom. If we don't have enough competitors at each of the campuses, it'll have to be held via Zoom. So for example, I think Ipswich is looking a little bit low at this stage. So we might have to hold that one via Zoom as such. But everyone, if you compete on Zoom, well, that's fine. We had people advance in the Grand Championship route to the finals, the grand finals, using Zoom. So you're not in a disadvantage. And Zoom is now the primary format for a lot of comps around Australia because of the whole COVID situation and the uncertainty about health, really. We want to make sure everyone's healthy. So we've all gone online. But yeah, this important rule document will set out everything, what you need to do. And sets out the prizes. The prizes have been increased, which has been put on our website as such. And yeah, I'll quickly just run you through a script. But that'll be it for the night, I think. Yes, here we go. So here's the script. So you'll have your entrance appearance, as I already mentioned. We'll have something called a dispensation with citation. So pretty much that's a USQ specific thing. So you know how in a lot of cases, for example, Holchester de la Tour, it's got the case numbers at the back. So in a moot, if you just say, Your Honour, we may dispense with all citations and just refer to cases by their common name. you don't have to worry about saying these annoying things. So, for example, you can just say Rochester and the De La Tour rather than going Rochester and De La Tour, 1853, 118, English Law Reports, 920, page 922. It's a bit of a mouthful, isn't it? So it's just easier how you refer to it. If you just say this one little simple thing, that'll fix it. So only the appellant has to say this as such. If the appellant says this, the judge will go, that'll be granted to both sides. So that means that no one else will have to worry about saying it. If the judges say no and they won't do in this competition, you'll have to say the entire word. You'll have to say the whole wordy thing. But that won't happen in this comp. Okay, so summary of the proceedings or a summary of facts, just a quick explanation of the facts of the case as such. So I was going to show you a copy of what I did for the moot, but unfortunately that's a little bit too easy, so I won't send that to you. But essentially it's just a summary of facts of how things progressed in the original circumstances. So what facts around Mr. Randall? What was his life like? What led him up to convicting the offences? The summary of appeals is just outlining, firstly, what the appeals are. So we've got the 2 appeals which are in the question and explaining what your arguments are going to be. So they're pretty brief. And then, just explaining, again, IROC, your speech is pretty much just your submissions, but more fleshed out. So if you look at the examples they're giving you, you can see it's been a little bit fleshed out a little bit more. It's not too much more, but it's just enough to make it more of a script type thing rather than just a formal writing, and gives more of an explanation. So you use more facts as such and just explain the law in a more in depth. And then when you conclude a ground, you go something along the lines of, Your Honour, that concludes submissions in regards to the first ground of appeal. If Your Honour has no further questions, I will now make submissions in regards to the second ground of appeal. Just noting that you're finished with that ground of appeal and you're moving on. The bench always loves that. And second ground, something similar. And finally, when you end, you just summarize your submissions. So Your Honour and summary submissions are. You can literally distill it from your outline of summary of appeals from up here. And then just ask Your Honour, does Your Honour have any further questions? So do they have any further questions, or are they finished? And then Your Honour, that concludes submissions for the appellant. So that's pretty much it. Okay, do you have any other questions at all? Nope. Well, thanks for that. Thank you everyone for coming, and I hope you all have a good night. I'll take any questions via email because I do have to run now, but I really appreciate you coming tonight. And I will stop the screen share, but if you have any questions or anything, please let me know. I'm happy to help out. Just send me an email or anything. I'm happy, or a phone call. I'm happy to take any inquiries about it. And the final thing I should mention is, if you do find there's going to be times where you find it's hard and you might feel like dropping out. Don't drop out. It's worth it. Just keep going through. Give me a call. I'll give you as much help as I can. There are circumstances such as like family matters or, sudden assignment popping up. I do understand, but consider going through. It's worth it in the end. You learn a lot of experience. It might be stressful at the time. A lot of the times it'll resolve pretty quickly. The amount of times in the moot I've been incredibly stressed out to the point where I've been almost rocking against the wall. It's crazy, but once you get on the day, once you actually, do your bit, give your submissions to the judge, you'll feel this wave of relief and it'll feel so good, and you'll learn some important skills, and the judges will give you some amazing feedback. And if you make it through to the final 2, hey, you get your chance to get your name on a trophy and get some prize money. But yeah, thanks for everyone for coming, and I hope you all have a good night. Thank you. See ya.